Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain the Illinois commercial litigation process. Commercial litigation is any type of dispute that comes about in a business context. This might be breach of contract, partnership disputes, copyright, trademark, licensing, and other intellectual property disputes, shareholder issues, or a number of other types of disputes that are business related. The steps of a commercial litigation process are as follows. First, the person who is suing the other party files a complaint. A complaint basically lays out the allegations that would lead to a cause of action. A cause of action is what entitles you to damages. So you lay out allegations, factual allegations that would, if true, lead you to a right to recover damages or some other remedy from the court. Then, once that complaint is served upon the other party, the defendant will file an answer. An answer either admits or denies each of the allegations in the complaint, so you know what facts are at issue, what facts actually have to be argued about at trial. If the complaint fails to state a cause of action, even if true, then the responding party, the defendant, might file something called a motion to dismiss, which seeks to have the complaint thrown out of court, and sometimes, if it is the person who filed the complaint, will have the opportunity to refile it to make it actually state a good cause of action. So sometimes a motion to dismiss is filed at this stage, sometimes an answer is filed. Once an answer is filed to the complaint, the parties are at issue. This means we know what the issues involved in the case are. The next step is to move on to written discovery. Written discovery consists of a couple requests that each party will send to the other in order to understand what their theory of the case is, what they're going to be arguing at trial, and what facts are at their disposal. Because we don't want people to be surprised at trial. We want, despite all the television shows that show stuff like that, we want both parties to be operating out of the same set of facts. So written discovery consists of interrogatories, which are written questions that the other side has to answer in writing about the facts as they understand them or about their legal theories. They consist of requests for production of documents, which requests that the other side provide documents that are in their possession so that both sides have the same set of documents they're working on. And then they also consist of requests to admit. So these are requests that the other party admit facts that are not in dispute or explicitly deny them. And if they're denied and later it's proven that the other party should have admitted them, then there may be some sanctions involved for that. So that narrows the issues that the parties have to actually litigate about at trial. At this stage, we also have subpoenas, which are those types of requests, except for the admission of fact requests, the interrogatories and production of documents that can be issued to third parties that aren't part of the case. Once written discovery is complete, the next step is depositions. So this is where the other side's attorney will interview each of the parties or their witnesses about what they intend to testify about at trial so that we know what the witness's testimony will be and there's no surprises at trial. If the witness changes their testimony between the deposition and trial, you can do something called impeach the witness, which means that you basically ask the trier of fact, whether that's the court or the jury, to decide, is this person lying now or were they lying then in their deposition, and it goes to the credibility of the witness. Once depositions are complete, and actually throughout the entire course of the case, there might be motion practice and settlement efforts. Settlement efforts are most likely after all the facts are on the table and depositions are complete, but they can happen at any stage of the case. We try to usually settle cases as early as possible, even after the initial complaint and answer are filed, so that the parties don't have to spend legal fees to get to a solution to their case. But often settlement happens after depositions, and this might be a pretrial settlement conference where the judge is involved in helping the party settle, or a mediation where a third-party mediator helps the party settle. Motion practice might consist of the motions to dismiss we talked about earlier, or motions for summary judgment, which means that there's no need for a trial, there's no facts in dispute, and I'm entitled to judgment as a matter of law. Or it might be motions to compel discovery or any other sort of different types of motions that are involved in the case. Once all the motion practice and settlement efforts and discovery are complete, then you're ready to hold a trial. And at a trial, you basically put on your evidence to make the judge or the jury, depending on who the trier of fact is in the case, side with you on the facts that are in dispute, and then the judge will issue an order determining what the result of the case will be and what the remedy will be, if there will be a remedy that the court will issue. So that's what the process for commercial litigation looks like. If you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, please give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.